This is where the Texas Sovereignty Act and other acts like it come into play. Reading from that act, under Section 1, Subtitle Z, Title 3 Government Code is amended by adding Chapter 394 to read as follows: Unconstitutional Federal Directive. This would not be the first time that states declared the acts of the federal government unconstitutional. The most famous of these happened back in 1798 with the Virginia and Kentucky resolutions. From the Virginia resolution, that the good people of this Commonwealth, having ever felt and continuing to feel the most sincere affection for their brethren of the other states, and truest anxiety for establishing and perpetuating the union of all, and the most scrupulous fidelity to that Constitution, which is the pledge of mutual friendship and the instrument of mutual happiness, the General Assembly doth solemnly appeal to the like dispositions of other states, in confidence that they will concur with this Commonwealth in declaring, as it does hereby declare, that the acts aforesaid are unconstitutional, and that the necessary and proper measures will be taken by each for cooperating with this state in maintaining unimpaired the authorities, rights, and liberties reserved to the states respectively, or to the people. I wrote about these resolutions, including the outcomes, in more detail in my article, Can States Rein in the Federal Government? In more recent years, many states have also considered similar legislation, while others simply ignore federal laws like those involving the use of marijuana or assisting the federal government in enforcing their immigration laws. Now, a move of this importance should not be left to whimsical decision-making. Under Section 394.002, the legislature, by concurrent resolution, may determine that a federal directive is an unconstitutional federal directive and prohibit a government officer or employee from enforcing or assisting in the enforcement of the unconstitutional federal directive. The Texas legislature also recognized the constitutional authority of the federal government to call up the state's militia. This section does not apply to a federal directive that activates the state military forces as defined in Section 431.001. This act would have also required the legislature to be specific about which federal acts were unconstitutional and their impact on state officers and employees. Subsection 004. The legislature may not adopt a concurrent resolution described in Section 394.002 unless the resolution identifies the federal directive that the legislature determines is an unconstitutional federal directive, explains the basis for the legislature's determination, specifies whether a government officer or employee is prohibited from enforcing or assisting in the enforcement of the directive, including specific activities or forms of assistance that the officer or employee may not engage in, specifies the government officers or employees to whom the concurrent resolution applies as applicable, and specifies any other requirements the legislature considers appropriate to impose on a government officer or employee in order to comply with the legislature's determination. Such a concurring resolution would have required a two-thirds majority for passage. Such a resolution could be repealed, again, but only by a two-thirds majority. Lastly, the act would have made a statement about legislative inaction. Subsection 007. The fact that the legislature has not considered whether a federal directive is an unconstitutional federal directive under this chapter does not imply or create a presumption that the directive is constitutional or limit the authority of the Attorney General to challenge the constitutionality of the directive. Now, overall, this appears to be a reasonable and logical way for a state to reassert both its sovereignty and power as a part of the Constitution to oversee their creation.